Dear students, when I was going through the examination papers, I am seeing the case of Rylands versus Fletcher always being asked, either under strict liability, negligence, or things like that. I hope you are well aware about the facts of the case. Rylands versus Fletcher, which occurred in the year 1868, and from which the concept of strict liability was framed. Right? As regards the brief facts of the case, the defendant got a reservoir constructed to provide water to his mill. Of course, this was entrusted to an independent contractor. There were old disused shafts which were not observed by the independent contractor. After completing the construction of the reservoir, it was handed over to the plaintiff and he got it filled with water. So on that night, through the disused shafts, the water entered the neighboring mines, coal mines of the plaintiff, and they were totally damaged. Heavy loss was caused to our plaintiff. Right. He filed a case of tort. At that time, only common law principles were in vogue. Here, the court observed 3 points. These things you have to write. Number 1, dangerous thing. The rule applies if it is a dangerous thing. Dangerous things are like if gas is coming out, if electricity sparks, if the sewage comes on the road and causes heavy damage, explosives, and moreover noxious gases. Noxious gases means the gases which create nausea, by which you will get allergies and immediately get affected. The second point is escape. Right, dangerous thing is there. If it is involved inside, if it is there inside, it's okay. But when it escapes, the thing causing damage must escape from the area outside the occupation and control of the defendant. Here it was done. Then third point is non-natural use of the land. Suppose since there are coal mines, previously our defendant also definitely will be having so-called coal mines. But what happened? He has damaged or he has constructed a reservoir over the coal mines and he wanted to cultivate the neighboring lands. Thereby this trouble came into existence. So that also these 3 points you have to write. Then whatever damage was done, right, it's okay, it's happened, but since there is damage, you are strictly liable to pay the amount. That's what at the time House of Lords, that's what the House of Lords told. Right. But there are exceptions. Exceptions, number 1, and if you prove the exceptions, definitely you will not be held liable. You can escape the so-called strict liability also. That's why in India, Justice P.N. Bhagavati propounded the so-called absolute liability. The main difference between absolute liability and the strict liability is, in absolute liability, you cannot claim any exception. But in strict liability, you can claim exceptions. Number 1, plaintiff, the wrongdoer. Plaintiff, if an employer authorizes an illegal act and subsequently ratifies the same, definitely the employer, as he is liable, he will be held definitely liable. Second, act of God. You all know about the act of God, definitely. Even though he created artificial lakes, but if they swell due to the sudden cyclone or something like that, definitely it could cause damage and we can't help it. Then act of the third party. Suppose here the reservoirs were filled. Suppose if somebody causes a breach, if third party acts, then also you can happily escape. So these definitely, and plaintiff's own default also, you can take it as an definitely that exception. And third one, last one is there, statutory authority. If somebody does some negligent act which results in damage, definitely if it is done under statutory authority, definitely you cannot claim this compensation. It happened in the case of Nagareddy versus State of Andhra Pradesh. What happened? He cultivated some plants, he has grown up some plants, but at the time of construction of the Nagarjuna Sagar canal, the water has inundated the fields, which due to heavy sucking of the water, the plants died. Even then, the compensation was not given because it is the welfare measure. It is a welfare measure. So you have to write all these things while discussing Rylands versus Fletcher case. So it's an important case. Please mind it, study it thoroughly, and don't forget. Don't write in place of plaintiff, defendant. You have to remember who is Rylands and who is Fletcher. Right? Okay. I hope you will write the examination well. Right, thank you.